how much time are you requesting for the reset, Mr. Tejas?
I'd ask for 30 days. Or if that's too much, 2 weeks, whatever's easier for you.
Well, we can do it on, I mean, we've been doing them 2 or 3 weeks out just so that we can give the DA's office time to prepare. But in this case, I guess, because we're basically waiting for a report that we have no control over.
Yeah.
You think 2 weeks is enough?
I don't think so.
You don't think 2 weeks is enough? Okay, no, we'll do it in 4 weeks out. Isela, are you getting that?
Yeah, 4 weeks, right?
Yeah. If possible, let's see what Mr. Thompson says.
Okay.
Where's the DA's office?
They're conceding all examinations today, Judge.
That'd be fine with me.
It's kind of like college. Like if the professor doesn't show up within the first 10 minutes, it's not important enough for him. It's not important enough for me.
Yeah, you're gonna walk out and it doesn't count as an absence.
Meme used to do that when he would start court at 8. Like if the DA's office wasn't there, cases started getting dismissed left and right.
I heard. Missed an easy one. Good morning, Ms. Castillo.
Good morning, Judge. I'm sorry I'm late. I had the courts confused.
That's all right. Is Mr. Thompson around? Mr. Diaz says that they have discussed resetting the 11 o'clock or the 10 o'clock hearing.
I heard something like that, but I'm not sure. I'm not sure where he is, but I just heard from the legal assistant that probably was going to be reset.
Yeah, Elizabeth, it's just to give him more time. The police report's not in and I have no problems asking for more time. And so I was making that announcement. So if you can just join and concur, it's a bridge case. So customs needs to coordinate with PD to turn in the report.
Is that the case that was set for 11?
Yes.
Okay. Do you mind if I just text Mr. Thompson just to make sure?
Yeah, can you do that? And then the court is doing a separate recording, Mr. Diaz and Mr. Del Rio, on the court's computer recording, which is what I use when I magistrate defendants in jail. So that we're not using the YouTube recording.
Okay.
That's fine.
I just sent him a text, Your Honor. I'm just going to wait for him to respond.
Okay. And before I call the case, how many witnesses are you going to have, Ms. Castillo?
I don't have any witnesses, Your Honor. Your Honor, so Paul Thompson just replied. He said that that was his understanding, that it was going to be reset. He said, I guess he thought the same thing. We both saw the 49th and we were both thinking it was going to be with Judge Lopez. So I think that's what he was under the impression as well. But he said it was fine. He had agreed.
Okay. Mr. Diaz, as an officer of the court, are you averring that the evidence you seek is material to this case?
Yes, Your Honor.
Okay. The court will grant your request to reset. We're going to reset it in 4 weeks. Well, hold on. Are we going to put it back on the regular examination docket on Thursdays instead of Friday?
Yeah, they usually fall on the Thursday.
Yeah, the only reason we didn't have this yesterday was because I was doing in custody. So, Mr. Diaz, we're gonna go back to the regular schedule of Thursdays. So it'll be 3 weeks and 6 days, actually. But the notices will go out to both sides in reference to that. And that was in reference to booking number 2020-05. 264, the state of Texas versus Norma Angelica Mong. That will be reset for, what's the date?
You want to do September 23? That's the 3 weeks, 6 days.
September 23rd to 2021 at, what time do we start those at?
At 3.
At 3 p.m.
Not a problem, Judge.
Okay, so we'll be back on the regular schedule for that. If there's nothing further, Mr. Diaz, you're excused?
And that's September 23rd at 3 p.m.
Correct.
Thank you, Judge. That's all I have. Have a good weekend, everybody.
Thanks, you too.
Bye.
Okay, in the next case on the docket, the court calls 2020, booking number 2021-4578, State of Texas versus Jose Angel Chavez Ramirez. We're here on the defense's motion for examination trial. Is your client present, Mr. Del Rio?
No, he's in custody, Your Honor.
Isela, did we make arrangements for that or
I'm not sure, Joanne.
call Joanne in?
Okay.
I'm pretty sure the rules require for him to be present.
Yeah. How is the state wishing to proceed and justify its probable cause?
But that was going to be my question, but let's
Are they
wait.
going to concede?
Not necessarily.
I mean, when the guys in custody, did we ever call the jail?
Maybe. Let me call it. Try to
They were notified, so can you call? Thank you, Joy.
Or maybe they have the same issue that because I know the 49th, I believe, is having in custody docket this morning, if I'm not mistaken. I thought there was another court that was having.
Yes, no, Judge Lopez is doing his regular criminal docket.
Oh, okay.
You tell Joanne to see if the jail didn't log on with Judge Lopez.
I know the 111 is having in custody docket. I don't know if they might have got that one confused.
Well, go to both courts.
Okay.
Talk to, I think Sonia is the one that does the criminal for Judge Palomo. That we were expecting the jail to produce Jose Angel Chavez Ramirez. You have my link and everything, right?
Yeah, I know.
And that, and make sure Joanne knows the same thing. Although I think they'll probably be able to track it down.
Yeah, I tried it down with Joanne.
Yeah, let's see who's working the front desk at booking and see. They're usually pretty helpful.
Okay, no problem. I need your help with some incarcerated right now. He's in the cell 4G, Jose Angel Chavez Ramirez. I'm with judge and we're waiting and because it needs to be through Zoom too on an examining trial.
But make sure they know that it's with my link.
But it's with Judges Garcia's link. Do you know it? Yeah. It's Jose Angel Chavez Ramirez. Do you want the booking? I have it here. Okay. Okay, well, to my phone. You make an outside cross? Yeah, okay, yeah, coming to my phone. It's 956 333 6848. Okay, all right, I'm back. Thank you. They're looking for Corporal Reyes.
Hmm.
Mr. Del Rio, are you representing Mr. Chavez on the other charges?
Yes, but I didn't challenge the probable cause on those. It's just for the murder.
No, I mean,
But yes, on the smuggling charges, yes.
yeah. I remember getting this package because it was so long and I remember seeing that Judge Lopez had signed the original warrant. And but I signed the complaints on all the other stuff.
No, it's the 956. No, it's a separate link. It's the one for Judge Garcia.
956.
No, we're not in the 49. No, we're in his chambers.
532222.
Okay. Okay, all right, bye. So I think they're confusing it with the 49.
Yeah, it looks like they logged on to the 49th, but
Okay.
they've got it. There was no passcode required, was there?
Yes, there was, Judge.
Yeah.
Is it always the same
Yes,
passcode?
it's always a 5280.
No,
It's not?
no. Well, It was the same well, just this one, it was the same from the one that was reset from yesterday. But I don't believe it's the same passcode every single time.
I had to enter the 528807. That was my,
Yes.
Was that the one that popped up yesterday as well? I mean, for yesterday? Yeah. No, I think it generates the same passcode. Yeah, 528807.
Monday. 30 logging in? Okay, all right.
They're
Perfect.
coming in now.
No, I know. Thank you. Okay. Are you showing up, Judge?
Not yet, but Mr. Del Rio, Joanne mentioned that you might need a translator. I can do that. I do that quite often, actually, in the pro se court. I will make the statement in English and then translate it into Spanish if needed.
that'll be a lot easier, I guess, since there's no witness today.
Did Joanne tell you they were logging on?
Well, they told me, from the jail, I'm looking.
Oh, there we go.
Morning, Your Honor, Corporal Reyes, Webb County. Is this for Chavez Ramirez?
Correct, yes.
All right, so we get it, thank you. President, Your Honor, also needs an interpreter.
Sure. I'm going to recall the case. Good morning, Mr. Ramirez. Buenos días, señor Ramirez. Voy a estar traduciendo. I'm going to be interpreting for you. Primero voy a llamar la causa. I'm first going to call the case. The court calls booking number 2021-4578, State of Texas versus José Ángel Chávez. La corte está llamando la causa. Número de arresto 2021-4578, el estado de Texas contra José Ángel Chávez Ramírez. The first thing I have to do before we begin is to advise you, Mr. Del Rio and Mr. Ramirez, that he is entitled to make a statement. I do have to admonish you that this is being recorded, so anything he does say can be used against him at any proceeding or a trial. Lo primero que tengo que hacer es informarles que tienes el derecho de hacer una declaración, pero esta declaración va a ser grabada. Y si dices algo, esa declaración puede ser usada en contra de usted durante cualquier procedimiento o en un juicio. Is your client going to be making a statement, Mr. Del Rio?
No, Your Honor.
Ok. Y la pregunta fue si iba a estar haciendo una declaración, señor Del Río, y la respuesta fue que no. Okay, we're here on the defense's challenge to ask the prosecution to establish the truth of the accusations against the defendant. Estamos aquí en la moción de la defensa para establecer la verdad de los hechos en contra del defendiente. Ms. Castillo, are you here for the state? Señora
Yes, Your
Castillo,
Honor. Yes, Elizabeth Castillo on behalf of the state.
la señora Castillo está aquí para el estado. Are you going to have any witnesses?
No, Your Honor.
¿Vas a tener unos testigos? Y la respuesta, no. The court has to then inquire how the state intends to prove the veracity of the accusations against the defendant. La corte está preguntando cómo el Estado va a probar la verdad de las acusaciones contra el defendiente.
Your Honor, since the defendant was served with a warrant that was signed by District Judge Joe Lopez on 8/12/21, there has already been a determination by a judge that there was probable cause to arrest him for the charge of murder. So I don't think that this is something that should proceed in an examining trial. The judge made that decision on the 12th, and then counsel filed this motion on the 16th. So only 4 days had passed since he had made that decision.
El Estado está indicando que el juez López ya hizo una determinación que hay causa probable sobre los cargos en contra del defendiente y que nomás pasaron 4 días después que el abogado hizo esta moción. La indicación es que esta moción no es propia a este tiempo. Ms. Castillo, in all cases, the defendants, as part of their magistration process, are specifically advised that they have the right before indictment to challenge the veracity of the complaint against them. I think that's the whole purpose of the examination trial, is for the state to produce some evidence that the accusations are true. Again, the standard of proof is more likely than not, but they're challenging the veracity of the complaint made by the affiant in this case, which was the investigating officer.
Renee Mejia.
Well, he didn't print his name, but it's signed. I'm looking at the complaint now. La respuesta de la corte es que cada vez que hay una magistración, los defendientes les indican que tienen el derecho de contradecir la queja en contra de ellos. Y eso es el propósito de la audiencia de examinación, para darle la oportunidad al Estado a probar que son ciertos las acusaciones contra el defendiente. So your motion is, or your response basically, is that you're going to rely on the complaint as it is now?
At this point, yes, Your Honor. Defense counsel also, in addition to the probable cause, I know that he was also asking for bond. But in regards to the probable cause, I think at this point that it is sufficient for his arrest. It's still, this case happened less than a month ago, and it's still under investigation. So yes, the state is basically gonna rely on the warrant signed by Judge Lopez.
Well, I'm going to make a determination on this, but what I am going to do, Mr. Del Rio, if I can suspend with the translation for a little bit.
Sure.
But Ms. Castillo, I've reviewed the complaint, and let me tell you what the points are right now. I'm going to let both sides respond to this, but let me tell you what the court is relying on and what I wanted to hear today from this hearing. These are both two cases from the Texas Court of Appeals, the Supreme Court of the Texas Criminal Court of Appeals. And the first case that I reviewed that talks about how you're trying to tie in the murder through the law of parties. And both these cases are specifically in relation to how the state is required to do that. In Gross versus State, which is the site is 380 Southwest 3rd, 181 at 188, and I quote the Court of Appeals, there has to be sufficient evidence of an understanding or common scheme to commit the crime. Followed on by the second case, which I reviewed, Wooden versus State, site 101 Southwest 3rd, 542, which is almost on point, except in that case, the defendant was actually present, which from what I understand, the defendant was not present in this case. The evidence must show that at the time of the offense, the parties were acting together, each contributing some part toward the execution of a common purpose. The evidence will be legally sufficient to convict under the law of parties when the defendant was physically present, in this case he was not, at the commission of the offense and encouraged its commission by acts, words, or some type of agreement. So the court is basically asking how I get that from how the complaint is written. Right now, there's no indication in the complaint that Mr. Ramirez had a prior agreement. Clearly, it establishes that he picked them up, and based on the video that was obtained, that they called him and he picked them up. But I don't know how that extends towards him having a prior agreement to the offense being committed. But I'll let you respond to that.
Your Honor, so whenever, as per the complaint, the two individuals, well, the defendant was, or I'm sorry, Mr. Chavez was already stationary at the parking lot, and then the two individuals, the two other parties, walked straight to that vehicle that he was driving. So it shows that they already had a previous agreement to pick him up. So at that point, whatever the other two parties are alleged to have done, because of the law of parties, it is assumed that he was whether he was, I mean, we're not saying that he was the shooter. It was just saying that he at some point became involved, because it was obviously he was already waiting for them. It was already predetermined that he was going to pick them up. And it does say that they didn't approach the vehicle to talk to him.
No,
They just automatically.
No, there's no doubt in the court's mind that there was an understanding after the offense that he was going to pick them up. I seem to recall, or unless I misread it, but the surveillance cameras from the different houses that they obtained indicate that they were making phone calls to somebody after the offense for him to pick them up. Am I reading that correctly?
That's my understanding, Your Honor. However, I mean, this is a murder case. Even if they were like an accessory.
I understand the gravity of the charges against Mr. Ramirez.
Which, Your Honor, would, if they're so concerned about that, they have no witness here today to prove up their case. If they really are taking this seriously, they want you to take it seriously, but they're not doing the same, Your Honor. Where's the witness? They could have had the investigator here. It's their burden. They got the warrant. They had time to not get the warrant, but they decided to get it. They pulled the trigger. They started the clock. And these are the consequences of that. If they're not here to offer sufficient evidence to establish probable cause on the charge that they have them arrested under, then Your Honor has to discharge them. And more than that, Your Honor, if you look at the complaint, even if you took everything as true, untested, under the law, it's impossible for my client to be held under the charge that they alleged because it's deficient. Their act clearly dangerous to human life that caused the death was that he was the getaway driver. No one on earth can say driving people away after she'd already been killed caused the death. State law requires, and I can give you the site for the case. It's a Gilbert versus State. It's a Court of Criminal Appeals case, and it lays out the elements of the murder that they charged him with. And it says he must intentionally, knowingly causes the death, intends to cause serious bodily injury, and commits an act clearly dangerous to human life that causes the death of the individual. If you look at the complaint, Judge, they're not alleging law parties. One, they messed up there. They're actually charging him with what's called felony murder, 19.02 B2.
Oh, no, well, hold on a second. I think there is enough in there for the court. I don't know that they have to specifically cite the statute, but I think there was enough there.
The problem though, Judge, is they don't, there's no,
Well, hold on.
they have nothing to
I know
show
where-
any, yeah.
Mr. Carrillo, and I didn't, let me quote fully from the Wooden case. In that case, which I said was a little bit more on point, the defendant in that case was actually the getaway driver, and the court, again, quoting the court, standing alone, proof that the accused was present at the scene of the crime or assisted the primary actor making his getaway is insufficient to hold the accused criminally responsible for the acts of that person. So what the court is looking for, again, is that there was a prior agreement that he was going to help them, because from what I'm seeing is that there was an agreement maybe after when they called as, hey, we need a ride, which clearly he did.
Mhm.
But there's nothing in the complaint that to indicate that the defendant may have known what they committed. Now, he may have, but I think that burden does fall on the state to establish that there was again, as the Court of Appeals, the Texas Court of Appeals has indicated, that there was a prior scheme or plan to advance, in this case, the offense of murder. And I'm not seeing that in the complaint, and again, the state is not offering any evidence to prove up anything of the complaint, which I will do this, I will review, but I think once the defense asks for the examination trial, which they did in this case, I think that basically puts the complaint in question, and if the burden falls on the state to put some evidence to approve its veracity, which it has not done or is not doing right now. And, okay, and we all know that the district attorneys is free, regardless of my decision, or if I decide to dismiss, the district attorney's office is free to still indict Mr. Ramirez if it so chooses, if it has other. But I have 48 hours to make my decision. I am going to review, if you have any case law, Ms. Castillo, that suggests that you're not required to put on any evidence after the defense has challenged the complaint. And again, in this case, it's a little bit different because you do have a district judge signing the complaint and basically approving the probable cause, as you indicated. But I think that's all out the window once the defense raises or files its motion for an examination trial. And I think the burden does fall on the district attorney's office to put some evidence. And since the 11 o'clock hearing is canceled, I do promise a decision to both sides before noon. Señor Ramírez, estamos haciendo argumentos legales y por eso no traducí, pero te voy a dar la información. El Estado está indicando que el juez López que firmó, un juez del distrito firmó la queja, que eso establece la causa probable en contra de usted. Y la respuesta que estoy diciendo es que cada defendiente tiene el derecho de hacer una moción poniéndole la obligación al Estado de probar que es cierto las quejas en contra de él. Y en este momento el Estado no ha puesto ningún testigo y está diciendo de que es suficiente que lo firmó otro juez. No estoy seguro si está correcto eso, pero lo voy a revisar. Y lo que le estoy diciendo a los dos lados es que antes de 12 de mediodía hoy voy a tener una decisión sobre esto. Ahorita mi pensamiento es que la obligación sigue cayendo sobre el Estado de probar algo que es cierto sobre los cargos pendientes del homicidio en contra de usted. Pero si está correcto la señora Castillo, que ya está aprobado por un juez, puede ser que los cargos se van a quedar. También te voy a avisar que aunque haga una decisión quitándote los cargos de homicidio hoy, el fiscal del condado de Webb County todavía tiene el derecho a regresar y presentar su causa frente de un jurado grande, grand jury, y a ver si hay suficientes pruebas en ese tiempo en contra de ti sobre el homicidio. Puede ver que haya cargos nuevos sobre este cargo en contra de usted. Nomás le estoy diciendo que hay una probabilidad que después del mediodía hoy no va a tener esos cargos, pero no está fuera completamente libre de los cargos en el futuro. Ms. Castillo, I'll wait to see. You have my email directly to me. And Mr. Del Rio, if you would send me that case you just referenced, but I think the two cases that I cited, again, I did take the time. And Ms. Castillo, I understand the gravity of what's happening here. But even more so, I think it's in these types of cases, it's more important, as in all cases, that as the magistrate judge on this, that I do follow the law. I'm telling you what my understanding is that you have the burden here today and chose to rest on the complaint signed by the district judge. But my understanding is that the defense has put that at issue and that you had the burden. But if I'm wrong, you need to show me that case. Okay. Is there anything else then?
Do you want me to submit a proposed order, Your Honor?
Either one can submit a proposed order. I will ask you to do it in Word so that I can basically modify it based on the decision I make if I need to, and I will send it out to both sides. You can both submit orders, but I will ask that they be both in Word so that I can modify them.
Yes,
Eso,
sir.
so that'll be all for today. Eso va a ser todo para hoy, señor Ramírez. The parties and the defendant are excused.
Thank you, Your Honor.
Thank you, Mr. Del Rio. Thank you, Ms. Castillo.
Your Honor, until what time do we have to send you any proposed order or case law?
Well, I'd rather, I think the case law is more important at this point, but I want to have a decision out before noon. And I'm free till then. So the sooner the better.
And if I can, I'll look, Your Honor, to see if there's something. I think your understanding of it is right. If the law did say a warrant trumped an examining trial, then there would be it'd be a way around a very big chapter in the Code of Criminal Procedure, and it just doesn't make sense. So
I'll try to submit something as soon as possible. I do have court at 10, so I'll be working on that.
I mean, being fair to both sides, I mean, I'm going to look into the matter myself, but again, understanding the gravity of all of this, as you can, which is what I try to do with all cases, is to research and make sure that this is not just shooting from the hip, that I have some understanding and guidance from the upper courts as to what is proper in these cases. So, I mean, I am very concerned about the charges, and I mean, this is a horrible crime, and no doubt. But we know we have the laws in place to protect everyone, the accused, the innocent, and the victims. and it's my obligation to follow that. So as hard as the decisions might be, I'm guided by the principles and the law. So that's what the court's going to do in this case. All right. Thank you.
Thank you.
Thank you, Your Honor.
All right.